Hey guys, it's Kathy. Good morning, good morning. Hope you're doing well. I got some craziness for today. I got some craziness and then I also got some nerdy legal stuff. And I'm going to put that right in the smack dab right in the middle. So you sort of have to watch it or you'll miss the end. um, so it's just hilarious how the simplest questions just are so hard in a court. Like, what is your birth date? You would think that that is so easy, but no, it's hard. So I got people trying to answer very, very hard questions. And I also have a lot of sentences today. So we're going to see some judges pass judgment. There we go. Let's just start with your birth date. Let's just see. I mean, I'm sure most of us, I'm not all of us here. Most of us could answer the question, what is your birth date? But no, not in Indiana.
Do you swear or affirm any testimony you'll give today will be the truth? Okay, what?
And for everybody that is about to yell at me for putting a birth date on, you can't hear her name because you can't hear her at all. So it's okay. You don't know who she is.
What's your name? What's your date of birth? August 2nd of what? 89? I'm having deja vu. Did we go through this before where it says 88? Okay, let me look at your other case, see what I wrote on there. No, it doesn't say it. Bible order. You've had you don't have, do you have like an ID or something? You've had a lot of cases over the years, tickets and things, and every one of them says August 2nd of 88. Do you have any idea why 88 seems to be put on everything? Obviously. Well, okay, then what about this? Hold on. This is your other case. You filled that out and you put 88 right there. That's your handwriting, isn't it?
Yes, it is.
I can bring an ID.
Okay, why would you put 88 on that then?
I don't know. Maybe I was my ideas.
It's okay, you don't need to. I'm just looking at some paperwork here. Give me just a moment. Okay, this is your bond paperwork. When you bonded out about a week ago, you put 88 right there.
But my ID says 8. I was born in.
Can you get mail at this?
I don't, I don't have any idea what her excuse was because I couldn't hear her, but I didn't care. I didn't care what she said. She's been writing 88 on everything in her own handwriting. And now she's telling the judge it's 89. Or he's the magistrate. But same difference. Oh my gosh. All right. Now we're going to go to a pro se who is, as successful as every pro se always is.
Next state of Indiana versus Chris Brodine, 46D03, 1908 CM 2440, and 1910 CM 2943. Is it Brodine? Brodine. You are Chris Brodine?
Yes, I am.
And your home address, please.
Michigan City, Indiana, 46360.
Thank you. Date of birth, please. And all right now.
59.
Are these original charges?
Yep,
Okay, what is it?
4.5 years ago.
I'm sorry, the department credit.
Don't worry, the audio gets better in just a sec.
All right, are you planning to hire an attorney to help you with this?
No, Your Honor.
How do you plan to handle it?
I have 3 motions actually should be on your desk, should be an answer to them. Actually, I don't have one of them, but, motion to dismiss, failure to prosecute. And that was, I don't know the date on that, it's in my paperwork somewhere, but, another one was just August 16th, and stamped in open court, your court, on, August 16th, 2023, for a motion to compel / final disposition. And on July 24th of 2023, I have a motion to dismiss as well. That I've, like I said, they was put in them dates.
All right.
And I mean, this has been going on for 4.5 years. And I did approximately, I did a year or something here before I went to DOC. And all this is all done. It's 2 misdemeanors. I went to trial on June 8th of 20.
Mr. Brodeen, here's what we're gonna do. We'll set all of your motions for hearing. When were you released from the DOC?
I was released the 29th or something of this last year.
What
And then I came in front of you on the
What
4th December.
29th of December. Okay.
And then I came to court with you because you had a warrant
Would
for
you
my.
let me talk, please?
Mhm.
Thank you. So when you filed these, you were in the Department of Correction.
Yes, sir.
So they weren't set for hearing because you weren't available.
Yes.
Now you are available. And now I'll set them for a hearing. That's how it works.
Okay, we had hearings set for these.
I'm going to set a hearing date now.
Okay.
We've had things come up.
Mhm.
We've had weather. We've had illness. You were in prison for 5 years. Things happen. So I'm going to set a date. We'll have a hearing on all of your motions that you filed while you were incarcerated. You want to hire an attorney in the
No,
meantime?
I do
That's
not.
fine. You don't, that's fine. So let's do it. Well, let's see, whose case will this be? It'll be mine. All right, so we'll do it on a Friday afternoon. That's around 6 p.m. Are you available May 10th at 1:30?
May 10th?
Yes, sir.
May 10th at 1:30? Sure.
Okay. We'll have a hearing.
Things come up. You were incarcerated. Oh my goodness. All right, let's just pop into Christofino and see how his day is going. Just for a few minutes.
Gun is what you're saying.
That is what I'm saying. But again, remember, if you win your appeal on count 2, the enhancement goes with it. In other words, the court can't enhance a conviction that you don't have because the Indiana Court of Appeals or the Indiana Supreme Court vacated it.
Yes, sir. I got some understanding now. Thank you.
You bet.
Okay, now, before we get any further, everybody's about to get confused, and I can't answer any questions because I have no idea either. The jury is in the other room right now. He had a trial, and the jury is deliberating in the other room. And now he's about to take a plea. How that works, I don't know, but the plea is based on the jury's verdict. So the jury's deliberating whether he's guilty or innocent right now, and he's taking a plea. So somebody explain this to me.
So now I'm going to ask you, do you understand you're waiving your right to appeal your conviction as it relates to the firearm enhancement?
Yes, sir, I do.
Do you understand that by pleading guilty, you're giving up that right?
Yes, sir.
I'm going to give you your Rule 11 rights. In order to appeal a sentence imposed, you must file either a notice of appeal or a motion to correct error within 30 days of the date of sentencing. That's not today. That's going to be a date in the future. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have the right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you're unable to afford an attorney, I'm obligated to appoint one to represent you at no cost to you. Do you understand those rights?
Yes, sir.
Do you understand that the charge to which you're pleading guilty is page 2 of page 3, penalty for use of a firearm, and page 3 of 3, penalty for use of a firearm?
Yes, sir, I understand.
Do you understand that in order to be guilty of these penalty enhancements, the state of Indiana must prove beyond a reasonable doubt that on or about April 17, 2022, at the County of Elkhart, state of Indiana, one Dentrell M. Brown did commit a felony under Indiana Code 3542 that resulted in death or serious bodily injury, to wit, attempted murder, a felony as set forth on page 1 hereof, and the said Dentrell M. Brown knowingly used a firearm in the commission of the offense, all of which is contrary to the form of Indiana Code 305211B1, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. That was page 2. Page 3, the state of Indiana must prove beyond a reasonable doubt that on or about April 17, 2022, at the County of Elkhart, state of Indiana, one Dentrell M. Brown did commit a felony under Indiana Code 3542 that resulted in death or serious bodily injury, to wit, aggravated battery, a felony, as set forth on page 1 hereof, and the said Dentrell M. Brown knowingly used a firearm in the commission of the offense, all of which is contrary to the form of Indiana Code section 30-5-2-11B1, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Do you understand that?
Yes, sir.
So, Mr. Brown, am I correct? You understand the charge, that being penalty for use of a firearm, as an enhancement that you're pleading guilty to?
Yes, sir.
Do you understand the statute or the law that gives rise to that penalty enhancement?
Yes, sir.
The penalty on the penalty enhancement is a minimum of 5 years, a maximum of 20 years. Do you understand the penalty that you face for the penalty enhancement, use of a firearm?
Yes, sir, I do.
Do you understand that by pleading guilty to these charges, you're admitting the truth of all the material facts set forth in the charging information or to any offense included thereunder, only as it relates to the penalty enhancement? Do you understand that?
Yes, sir.
Do you understand that by pleading guilty, the judge will proceed with judgment and conviction, will sentence you without a trial?
Yes, sir.
Do you understand that the maximum possible sentence for the penalty enhancement is 20 years?
Yes, I understand.
Do you understand that would be added on to any sentence that you got on the underlying conviction, that being either attempted murder, a level 1 felony, or aggravated battery, a level 3 felony?
Yes, sir, I understand.
Do you understand that any history of prior criminal activity is an aggravating circumstance which can be used for enhancement of your sentence, such as prior felonies and or convictions?
Yes, sir.
Do you understand that the court may consider prior arrests not reduced to convictions as a history of criminal activity for sentence enhancement from the standard sentence to the maximum sentence?
Yes, sir.
Do you understand that I shall determine whether terms of prison shall be served consecutively or concurrently? However, if this crime for which you're pleading guilty today was committed while you're on probation, parole, on bond, or serving a term of imprisonment for another crime, the terms of prison for this crime and the other crime shall be served consecutively, regardless of the order in which the crimes are tried and the sentences imposed.
Yes, sir, I understand.
Indiana law provides that aggravating circumstances may be considered by the court in sentencing, and that in considering such aggravating circumstances, the court could impose consecutive terms of imprisonment for multiple offenses. Do you understand this?
Yes, sir.
The court may also consider mitigating circumstances favoring suspending sentences and imposing probation if appropriate. Do you understand this?
Yes, sir.
Are you now on parole, probation, under a withheld or suspended sentence, or on bond for another offense?
No, sir.
Do you understand that you could be deported as a result of the conviction entered in this case if you're not a citizen of this country, if you're here illegally?
Yes, sir.
Are you a U.S. citizen?
Yes, sir, I am.
Mr. Baldwin, are there any situations here that might give rise to consecutive or non-suspendable sentences?
Not that I know of.
Back to you, Mr. Brown. Do you understand that your plea of guilty may affect the imposition of harsher sentences for any future crimes?
Yes, sir.
Do you understand that the court's not a party to this plea agreement, is not bound by such agreement recommendation?
Yes, sir.
Mr. Brown, have you or has anyone else received any promises other than the plea agreement or been given anything of value to induce you to plead guilty to this charge?
No, sir.
Have you or anyone else been offered any leniency or special treatment other than the plea agreement to induce you to enter a plea of guilty to this charge?
No, sir.
Has anyone forced or threatened or placed you or anyone else in fear to induce you to plead guilty to this charge?
No, sir.
Do you feel that your plea of guilty is your own free and voluntary act?
Yes, sir.
Are you satisfied with your attorneys, Mr. Baldwin, Ms. Price, Mr. Bembry?
Yes, sir, I am.
Do you feel that they have properly represented you in this matter?
Yes, sir.
Is there anything you feel your attorney should have done for you that wasn't done?
No, sir, I don't.
Did you give your attorney all the facts you know and discuss those facts with him or her?
Yes, sir.
Do you want me to accept a guilty plea in this case as it relates to the firearm enhancement penalty?
Yes, sir.
Would you tell me what causes you to enter your plea of guilty in your own words? Mr. Baldwin, do you want to assist with the facts or do you want me to?
Sure,
Go
I
ahead.
can do that. Again, this is conditional. I know you're nervous about that, but nobody knows what that verdict is, okay? You understand that?
Yes, sir.
Okay. If the verdict comes back guilty on those two counts, you have to admit that the jury found you guilty and that while you were, you may not agree with it, but you used a gun in commission of count 1 and you used a gun in commission of count 2. Okay? You understand what I'm saying?
Yeah, I understand what you're
Now,
saying.
you may disagree with the jury, right? But if the jury finds you guilty of those counts, you used a gun in the attempted murder count 1. Would you agree with that?
Yes.
And if the jury finds you guilty of count 2, then you would agree that the aggravated battery count, that you used a gun in the aggravated battery count 2, right?
Yes, sir.
You admitted that up on the stand.
Yes, sir.
Okay. I hope that does that, Judge.
Ms. Clays, any additional questions?
Mr. Brown, for purposes of the enhancements, would you also agree and admit that you were in Elkhart County, the state of Indiana, when you used the firearm in both count 1 and count 2?
Yes, ma'am.
I have nothing further, thank you.
Dentro and Brown, the court takes the plea of guilty under advisement. Well, I'm not going to do it until sentencing. I'm going to do it until we receive the verdict from the jury. Do you understand that?
Yes, sir.
And then we'll dispense with anything else at this time unless, Mr. Baldwin, you've got something else.
I don't, Judge.
Ms. Clays, anything else?
Thank you.
For the record, let's note that Mr. Pitzer, Deputy Prosecuting Attorney, has now joined the proceedings. Mr. Pitzer, ready to receive the verdict from the jury?
Yes.
Mr. Baldwin, ready to receive the verdict from the jury?
We are, Judge.
Gallery, let's be clear on this. You have been very, very well represented during this entire trial. Let's not make the mistake of blowing it now. No matter what the verdict is, no cheering, no yelling, no crying. You just receive the verdict solemnly. I know you're going to do that for me because you've been nothing but ladies and gentlemen through the whole trial. Would you bring the jury in, please?
So the audio matched up at the beginning, but you can see as this goes forward The audio is just detaching from the video with this WebEx, and I don't know why, but that's what it does. But it's crazy. This guy just took a plea. If the jury finds him guilty, then he'll plea. If they don't, then he won't. They're bringing the jury in now. It will only be another moment.
You may be seated. Ladies and gentlemen of the jury, I've been notified by the bailiff that you've reached a verdict. I will have some questions, four-person. You will answer on behalf of the entire jury. Do you understand?
Yes, sir.
Ladies and gentlemen of the jury, have you reached a verdict in this case?
Yes, sir.
The four-person of the jury will please deliver the verdict to the bailiff, and the bailiff will present the same to the court at this time. State of Indiana versus Dentrell M. Brown, 20 CL1 2204 F16. Count 1, attempted murder, a level 1 felony. We, the jury, find the defendant, Dentrell M. Brown, guilty of count 1, attempted murder, a level 1 felony. It's dated and signed by the four-person. Count 2, aggravated battery, a level 3 felony. We, the jury, find the defendant, Dentrell M. Brown, not guilty. It's again dated and signed by the four-person. Count 3, criminal recklessness, a level 6 felony. We, the jury, find the defendant, Dentrell M. Brown, guilty of count 3, criminal recklessness, a level 6 felony. Four-person, is this the unanimous verdict of the jury?
Yes, sir.
Court accepts the verdict of the jury, enters judgment of conviction on count 1, attempted murder, a level 1 felony. Enters judgment of not guilty on count 2, aggravated battery, a level 3 felony. And enters judgment of conviction on count 3, criminal recklessness, a level 6 felony. Additionally, the court finds that the defendant understands the nature of the charge against him, to which he has pled guilty, that he understands the possible sentence thereunder, that the plea was freely and voluntarily made, that the plea is accurate, and that there was a basis in fact for the defendant's offered plea of guilty. The court grants the motion to withdraw the previous plea of not guilty. The court accepts the plea of guilty and finds the defendant guilty of said charge. As it relates to page 2, penalty for use of firearm enhancement, court enters judgment of conviction against Dentrell M. Brown on page 2, penalty for use of firearm enhancement. Court revokes the defendant's bond. Court orders pre-sentence investigation report to be prepared and filed with the court by probation. Court schedules sentencing for Mr. Baldwin. I was looking at April 4, 2024 at 8:30 a.m. Is that okay with you?
Yes.
Defendant ordered remanded back to the sheriff. Ladies and gentlemen of the jury, it's my custom and practice to come back and talk with you about the trial and questions you may have. I also invite counsel from each party to come back and talk with you. I want to be clear on this. If you've had enough fun in circuit court this week and you want to get back to your family and your lives and your jobs and everything that goes on with it, you are not going to offend me in the least. I think by now you know there's nothing you could do that would offend me. You
I
do
can
not
try.
need to stick around, but if you want to do so, I will make myself available. I think the attorneys will also, because they'll want to ask you some questions. Again, you go with my deepest heartfelt thanks. I know this has been a really tough week for you. I know that this was tough decisions you had to make. But do you now understand why I start this whole trial off by saying, without fine citizens like you, we have no justice? Not in civil cases, not in criminal cases. We need people like you. I really appreciate your
He has pretty hair from the back.
taking the time from your lives to come in and assist Elkhart Circuit Court. I discharge you for the last time. If leave the iPads here, you take everything with you, you go in the back, the bailiff will give you whatever paperwork you need. Thank you. I don't think I said this for the record, but obviously, in light of the fact that there was a not guilty verdict on count 2 aggravated battery, the court is not entering any guilty plea that I accepted conditionally on the firearm enhancement. That's gone. Mr. Pitzer, last chance, any record you need to make?
No.
Mr. Baldwin, any record you need to make?
No, Your Honor, thank you.
Thank you all.
That was crazy. I've never seen that before. I've never heard of it. I didn't know you could do it. So now we know that we can do this. And, you know, we know that most cases go to trial or not guilty or they don't make it or whatever. So from now on, guys, tell the prosecutor right away that you want a jury trial and you want to plead just in case the jury trial doesn't go your way or whatever. I'm going to try it. I'm going to go break the law just so I can try that. Okay, this next 5 minutes is just chaos. Like, just when it's not crazy chaos. No one's screaming and yelling, but this whole court docket went sideways for 5 minutes, and then it went back on track.
Have assigned and authorized the claims and authorized Mr. Dwale and Mr. Saeed to carry out this litigation. But the problem is, especially with respect to Capital Home Healthcare, the defendant has control, not by majority ownership, but just by her access to the corporate access in the office. And my clients were unable to, they requested in discovery that these documents be turned over. But again, the written discovery was propounded January 12th, and it's been almost 2 months, and we don't have a response, hence the request for a hearing. But all of these issues were to be sorted out in discovery. It's just we've been thwarted at every attempt to obtain discovery from the judge.
The reason why it's a little blurry right now is because I accidentally hit a button which showed my computer, and I had stuff there, so I just covered it up with another clip of this same court and blurred it. It's only for 30 seconds, so it's almost over.
Defendant.
All right.
Your Honor, if I may respond.
No, I don't need a reply. Here's what the court's going to do. The matter is currently set for a jury trial. It's set just less than a month from now. It's set April 8th. It's clear that the depositions have not happened. It's clear that discovery is not complete. It's clear that mediation has not happened, which I think is essential in this case, given, how shall I say, the broad nature of the allegations and the mild nature of some of the admissions. It seems to me that there is some middle ground here. The defendant, Ms. Onyenwere, has selected counsel. The court is frustrated because when she released her last counsel, I asked her, are you going to be able to get counsel on this quickly so that it doesn't delay the trial? And her answer was, oh, yes, Your Honor, I'll be happy to do that. And that simply didn't happen. And then she ignored her responsibilities when she was pro se and basically said, well, I'm going to get a lawyer, and didn't answer those things, which is not sufficient. But the place that we're in now is that she has a lawyer. I'm told that she's retained that lawyer, that lawyer is ready to litigate the case, has done significant looking at the case at this point, is preparing a response to the motion for summary judgment. And neither lawyer, I think, is properly prepared to go to trial. And this will turn into one long discovery mess at trial. So I understand the frustration of the plaintiff, but in the totality of length of the case, this case is only 280 days old from filing. It's just about 7 months from the answer being filed. So we set it relatively quickly for a civil matter. So the court is going to grant the continuance. I think it is better to allow counsel to confer with one another to get the discovery accomplished so that they can figure out what's really happening in this case, so that they can have fruitful discussions and fruitful mediation prior to trial. So the court will grant the motion. What I'm inclined to do, since you're all planning to be here on the 19th to talk about some other issues, is to wait until then to schedule it so that Ms. Onyenwere is present, so that we schedule it on everyone's calendar. So I'll grant the motion. We'll reset the trial, though, when we meet again on the 19th. Anything else for the plaintiff?
Nothing further, Your Honor. Thank you.
Anything else for the defense?
Nothing, Your Honor.
All right. Mr. Williams, I don't know if you have conferred at all with plaintiff's counsel, but we may as well start talking and start figuring out when to set things and get things going here so that we can get things calendared as quickly as possible.
I did have one request. Mr. Williams, are you still on?
I'm here, yep.
So I tried to reach you several times to schedule Miss Onyenwere's deposition. I had meaning to ask you about that if you had appeared today. We were talking March 15th. Is that still available? Because we would have to get the notice out today.
Counsel, I mean, we can confer about dates. If you're proposing March 15th, that's fine. Put it in an email. I'll pass it on to the client.
You had already proposed that to me is the issue. I don't want to.
Come again?
You had already proposed the 15th to me, and we said yes, and then you didn't respond to me when I asked to confirm it. Sounds like the answer is no, and I don't want to waste the court's time conferring in front of the court.
Too late.
Well, I think we can talk about that, not in front of the court, if you don't want to waste the court's time. But in terms of March 15th, I think when I came on, I was trying as best as I could to put things together. The complaint in this case is just, the operative complaint is the amended complaint. And in trying to prep a client for that, I mean, anyway, it's something we can discuss.
Okay, thank you.
All right. We'll see everyone on the 19th at the scheduled time. Thank you.
Thank you, Aaron.
Why the judge allowed that to happen is beyond me. But both of those attorneys clearly knew better, and they did it anyway, right on his record. So I tried to start getting the name of the courtroom in the top left corner so that we know where we are. So we're in Colorado. This only works in Colorado. We're in Arapahoe, which I think is a felony. Anyway, we're in Arapahoe. So now we know this judge is in Arapahoe, and we can start learning these judges together. I don't know his name. Darren Volley? Okay. So Darren Volley, He just lets attorneys go at it in his court on record. Oh my. While we're going through lawyers acting crazy, we're going to go through another one. Now this next 21 minutes is just legal. It's more legal than anything else, but it's interesting. It's very, very, very interesting.
Ms. Abbott. He was engaged in the PSI because it was ordered by the court, but he was not waiving his privilege to his medical records or his educational records so that attorney that used to represent him could use.
Okay, well, I think there might be some questions because as whether there's a potential implied waiver because the district attorney has, in the Boulder County case, has access to all of that information. So it's no longer between Mr. Lovejoy and his medical professional. All the information from the PSI is provided to the district attorney in the Boulder County case.
Not disseminated to anyone.
I know, but the argument I think we're going to have is whether there is an implied waiver by providing that information to the district attorney. I think we can acknowledge that there's been no signed written waiver by Mr. Lovejoy. Are there any other questions as to the court's order?
Because I'm confused because anytime a defendant engages in a pre-sentence investigation, that information is released to the prosecuting attorney who's ordered not to disseminate it, and the attorney representing the defendant. Is the court making a determination that once a PSI is filed with the court as suppressed, that all information in the PSI is now available to everyone?
I'm not making that determination. The determination that I made was that there's potential argument that a defendant is not required to provide medical information as part of a PSI. So the question is, did the defendant provide medical information to the PSI writer to be provided to the district attorney such that it might rise to the level of an implied waiver? I'm not making that determination today. I'm acknowledging your record that there's no signed written waiver, but that does not alleviate a determination as to whether there's been an implied waiver based upon the fact that it was simply provided in the PSI. I'm not foreclosing that. So that's my ruling today. I'm not saying one way or the other. I'm just saying a written waiver is not necessary because there can be a potential implied waiver. But did you have any questions as to how we're going to be proceeding on Monday?
A lot of questions, but I'll just kind of go with it on Monday.
Okay. All right. I want to get into the affirmative defense or the defense of alternate suspect. Ms. Abbott, I'm going to turn to you first. I think as part of the Elmar analysis, I think it is up to the defendant to at least provide an offer of proof so that the court, that there is some form of non-speculative connection between the alternate suspect evidence and the charges in this case. So I'll turn to you.
And Your Honor, just to be clear, I don't think the statute nor Elmar explicitly states that we have to make an offer of proof. I think it is on the prosecution to request an offer of proof.
I'm requesting an offer of proof.
I think they requested it this morning.
Yes.
So I think we're at the point where I need to have that was the purpose of this hearing.
Right. And I think procedurally and factually, we're in a very different position than the Elmar case. Here, we have allegations that are occurring over years. And we have provided this court as well as the prosecution with notice of an alibi because for much of the time that Mr. Lovejoy claims that he was being molested by my client was actually incarcerated. So then we come to a question of who exactly had access to Mr. Martinez. And as we don't know how many different men were in and out of Genesis Salazar's life, We do know that there were allegations made by both Genesis via the protection order that Joseph Salazar, her biological father, was abusive, at least towards her mother. And then Sean Lovejoy, in the pre-sentence investigation report, indicates that his grandfather was physically abusive towards Sean, as well as sexually abusive towards Sean's grandmother. I think the connection here is that in Genesis's reports and in her statements, she indicates that her parents would watch her children, which includes Sean Lovejoy, and that this is something that our expert would be able to testify to as far as how people can make allegations against other individuals to either avoid implicating a family member or even have their facts wrong. And so I do think that this is fair fodder for cross-examination of Mr. Lovejoy. This is something we should be able to bring up. I do think that there is more than just speculation that Mr. Joseph Salazar is the actual perpetrator in this case, particularly because of his access to Mr. Lovejoy, and that we should be allowed to state to the jury that Mr. Lovejoy is either not actually a victim or that he is wrong about the person who perpetrated these crimes against him. And there's enough evidence that Mr. Salazar was violent towards Sean and sexually abusive towards Sean's grandmother, that there is a sufficient nexus between endorsing Mr. Salazar as an alternate suspect as the actual perpetrator of these crimes.
All right, thank you, Ms. Abbott. Mr. McGarry?
I guess I don't see the relevance because hearsay that Mr. Lovejoy allegedly said to the PSI investigator who wrote down in a report that Miss Abbott was not allowed to access. Someone telling Mr. Lovejoy that his grandpa may have sexually assaulted his grandma at some point in time has no relevant bearing on whether or not Mr. Lovejoy was also sexually assaulted by his grandfather. I don't know if he was sexually assaulted by his grandfather. I've never asked him that question. This trial is about whether or not Mr. Martinez sexually assaulted Mr. Lovejoy. Every argument that Ms. Abbott just made is pure speculation. And another concern I have is Ms. Abbott learned this information 2 days ago, yet in her argument says that her expert will now be able to come in and talk about how Mr. Lovejoy is somehow making up false memories about Mr. Martinez when it's actually his grandfather that's perpetrating against him. The expert summary has no disclosure regarding the defense arguing that Mr. Lovejoy has false memories or his memories have been altered somehow. And then to even tie that to a specific individual who Ms. Abbott didn't even learn about until 2 days ago is another example of how, again, on a Friday afternoon, I'm scrambling to figure out what exactly we're arguing, what is going to happen next week, what is the permissible boundaries of all of this testimony that's just been thrown at me. So as it relates to the relevancy portion of alternate suspect, I don't believe Ms. Abbott has sufficiently argued how a one-off sentence in a PSI, again, that she wasn't allowed to read, all of a sudden can form the basis of a legitimate alternate suspect theory next week.
All right, Ms. Abbott, any additional record?
I find it frustrating that Mr. McGarry claims that this is the first he's ever heard of this when we spoke on the benches outside of this courtroom. And I told him that I had this hunch that the grandfather was actually the person who perpetrated this. We sat on those benches. I said there was a protection order from 2010. I don't know anything more. I can't prove it, but this is a working theory. And then 2 days ago, when I accessed this PSI, I see these allegations from Sean where he says that his grandfather was physically abusive towards Sean himself. That that's not relevant and that this is completely sprung upon him. This is information that can help confirm my suspicions and confirm my working theory. This was information that was just learned when it was confirmed, but I didn't have enough when I only saw a protection order from 2010. This is additional information. In Dr. McAuliffe's expert endorsement, he does talk about cross-contamination and source monitoring errors, as well as stereotype induction, confirmation bias, expectancy effects. These are things that, of course, Dr. McAuliffe cannot talk about the credibility of Mr. Lovejoy, but you can talk about these things in broad strokes and how if somebody is told that a particular individual is a bad person, then that can confirm their bias. If they are told that somebody is a good person, then that can confirm their bias the other way and impact their memories. These are all things that are contained within the expert report. So I do think that by Mr. Lovejoy confirming in his PSI that he himself was a victim of physical abuse from his grandfather, and there is a protection order that is 2010C113, that his mother got a protection order protecting Sean from his grandfather, there is more than enough than just pure speculation for us to argue that the perpetrator could have been Sean's actual grandfather.
Good, thank you. Okay, well, the court, I've reviewed the decisions in People versus Dye as well as in Elmar, and the statements by the Colorado Supreme Court is that the admissibility of any alternate suspect evidence is based upon the strength of the connection between the alternate suspect and the charged crime. Alternate suspect evidence is admissible only if it establishes a non-speculative connection or nexus between the alternate suspect and the crime charged. Because the touchstone of the relevance in this context is whether there is a non-speculative connection, it must create more than just an unsupported inference or possible ground for suspicion. Otherwise, as the Colorado Supreme Court has stated, there's a risk of speculative blaming that heightens the prospect of jury confusion and invites the jury to rest its verdict on emotion or prejudice. Evidence merely showing that someone else may have had a motive or an opportunity to commit the charged crime is considered too speculative because it gives rise to no more than grounds for possible suspicion. There must also be evidence circumstantially or inferentially linking the alternate suspect to the charged crime. This is again determined on a case-by-case basis. And here, as I understand it, the assertion of an alternate suspect appears to be based on the named victim's statement made during the course of a PSI interview that his grandfather and his grandmother divorced due to the grandfather's physical and sexual abuse of the grandmother, and that the grandfather did physically abuse him, and then to be supported by the existence of a protection order with allegations that the grandfather physically abused the named victim in this case. However, there is no indication or evidence linking these statements against the grandfather to the allegations in this case. There's no allegations anywhere that the grandfather sexually assaulted anybody outside of the statements that are made in the PSI. From the court's review of the public records, no charges have been filed or any indication of any sexual abuse or sexual assault. There's no evidence that Mr. Lovejoy's statements or the named victim's statements here are based on any personal knowledge or based on him actually witnessing any sexual abuse or sexual assault of the grandmother. And there's no potential corroborating statements or other link or nexus from the grandmother or from the grandfather. Doesn't appear to be any link between the allegations against the grandfather identified by the named victim and the allegations that are present here. In fact, from a review of the paragraphs and the statements in the PSI, there's a clear delineation between the physical abuse allegedly perpetrated by the grandfather and the abuse allegedly perpetrated by Mr. Martinez. As the court understands it, that the argument here is that if the jury were to believe that Mr. Lovejoy's grandfather sexually abused his grandmother and physically abused him, then the grandfather must also have been the person who sexually abused the named victim, or Mr. Lovejoy. This does fall within the purview of speculative blaming that is prohibited by the Almar decision. In addition, there are several questions regarding the admissibility of any of these statements or evidence under Colorado Rule of Evidence 602, Colorado Rule of Evidence 404B as potentially other prior act evidence, as well as considerations under the Rape Shield statute. So I do find that under the decision in Almar, as well as under Rule 402 and 403, that the evidence regarding the proposed alternate suspect is speculative, and that evidence is excluded. Dabbitt, Ms. Blodgett, any questions as to the court's order?
No questions. Obviously, we do object to this court's ruling and Mr. Martinez's right to present a defense to due process of law or due process and to effective assistance of counsel under both the Colorado and United States constitutions.
McGarry, any questions as to the court's order?
No questions, thank you.
All right, parties, we will reconvene for trial on Monday at 8:30. I'd like you to be here promptly. I'm going to try to see if I can get much of my docket covered. I think we have some issues because Division E had a trial that's being covered here, and another, I think Division L is also in trial. So I'll talk to the other judges and see if I can get a portion covered so we can address the PSI issues on Monday.
If the court is able to get coverage, can we see if Division Q is available just for our office's coverage needs?
I will reach out. I think he has left for the day, and I think he may be taking the Division E docket on Monday, so that might be a little too much. So I will converse with the judges and see what I can do.
Thank you.
All right. Thank you all.
Additional, quick issue that has been brought to my attention. I reached out to Boulder just to confirm that Mr. Lovejoy will be transported here next Tuesday or next Monday, whatever day they pick. The response I got back was that because he has a sentencing hearing on the 13th in Boulder, they're not going to release him. And I don't think that's, writ is a court order. But I've never had someone say that they're not going to transport someone. So I wanted to raise that issue to see if the court has dealt with that before, if there's anything additional, either myself or any other orders the court could issue to direct them.
I have not, Denver repeatedly and regularly will refuse to transport anybody if there's a court conflict within the week. There's a possibility that on Monday we can reach out and just ensure. You can talk to the Adams County Jail. You can talk to the Boulder County Sheriff's Office. Try to ensure it is a court order, but at the end of the day, the court's resources, I think, would be to hold the Sheriff's Office in contempt, or you can make a request to hold the Sheriff's Office in contempt. But I'm not sure that I can do anything in advance. So I think the best course of action is to continue to attempt to engage the Boulder Sheriff and the Adams County Sheriff to ensure that we have a transport for that Tuesday and then make them feel comfortable that Mr. Lovejoy will be returned that same day.
Can we convene early on Monday to discuss and see if he's here, because my concern is that we impanel a jury on Monday and then they don't bring him.
Is he coming on?
They usually bring him either the Sunday or the Monday before the writ date, because they house him since the writ is for him to be here at 8:30 or 8 on Tuesday. They'll transport him either the day or two prior.
Okay, so I thought they only did that up for Department of Corrections, that anything that's in the metro area, then they bring them the same day.
That's
So
my understanding.
I think we're gonna have to just have an open line of communication with everybody. Again, we're meeting here on Monday morning and we'll address any issues as they arise. But we're just gonna have to have an open line of communication between your office and the Boulder Sheriff and the Adams County Sheriff.
And so if they are not willing to transport him, and they tell me that again in my communications this weekend, trying to figure out what we're going to do with the jury. The people are also flying a witness in. So that's why I'm trying to front load these issues.
Okay. Well, I think we're just gonna have to see how that one plays out, and you'll have to make any requests on Monday morning if you so choose. I don't know how else to address it at this point, because I don't know if they're gonna bring them or not. So we'll just address any issues on Monday morning. Okay, I'll see everybody at 8:30 on Monday morning.
Thank you.
Thank you.
I was a little shocked by both of those things. First, I mean, you're in trial and, beyond reasonable doubt. And I thought, watching TV shows, you're allowed to at least put the blame on someone else enough that there's enough reasonable doubt that you're not found guilty. But I guess you can't do that if it confuses the jury. So that I was a little shocked at. I thought that was an easy win for her, and she lost. And then the judge isn't going to talk to the jail to make sure this guy's here for court. He's just going to wait till Monday and see how it plays out when the jury's going to be there and a witness is being flown in. That I didn't understand either. I thought the judge would pick up the phone and talk to them. But no, I'm 0 for 2, which is why I'm not a judge. Okay. Let's get back to some sentencing. 2 different sentences in this court. I show you the first one, and then just so you guys don't, well, you know what? I don't want to give it away. Here we go.
Provide the pre-sentence confinement credit calculations to the court, but I know Mr. Gauna has a statement that he would like to read to the court.
Mr. Gauna, you have the right and the opportunity to make a statement. What would you like to say?
Your Honor, I want to first take the opportunity and the time to thank everyone, the court, the DA, the family, and everyone involved in the steps we are taking to get my life on the right track. I also want to acknowledge the effects and impact my actions have made on the community, myself, and my family. I can't undo my actions that brought me here today, but I can do my best to utilize the opportunity to make the most out of my life by first being sober and building a healthy routine and lifestyle. Being in community corrections is going to allow me a chance to build support, secure long-term employment, and reach my goals and become a trusted, independent man, father, and son. I'm brave enough to ask Your Honor for as much leniency as the agreement will allow and sentence me to a 1.5 years of community corrections, because I believe in myself enough to know that I can accomplish all of my personal goals and satisfy the court and community to the point of becoming a trusted member of the community within the time.
All right, thank you.
Yep.
Well, I'm not happy with the predicament that I'm facing with respect to my sentencing options, but on the other hand, it does sort of put everybody on the same page with respect to what the right thing to happen is, and I guess I can live with that. Mr. Gauna, you've been in this court system since 2015, at least. How old are you?
24, Your Honor.
Yeah. So, I mean, the number of judges that you stood in front of at the time of sentencing is a couple dozen. And here you are with another 1, 2, 3, 4, 5 new cases, a new felony. And I'll be honest with you. If I had the availability to impose a sentence to the Department of Corrections longer than 3 years, I would, because you've earned it. On the other hand, your lawyer points out that you're doing well in the jail. You're wearing whites. There appears to be some sort of plan with your family, which is positive. And so I am going to sentence you to community corrections, but it's going to be for 3 years. I understand requesting a shorter term. That's what Ms. Briggs did. I understand sometimes you think that's what you deserve or what you need to do. I would just tell you that I couldn't justify any shorter term than that, particularly when I look at your criminal history. It's horrendous. And you've been in and out of the system forever.
I understand, Your Honor.
And I'm going to sentence you to community corrections, and I know you've already been sentenced to community corrections and bombed out of that after a short period of time. I am going to recommend that you complete an IRT program before you begin community corrections. I know that was tried before, and you got discharged unsuccessfully after that program 3 days. All I can say is you're about out of chances. I don't know how else to put it. You got to get a grip on whatever it is that's causing the criminal behavior. If it's alcohol, if it's drugs, if it's mental health. I suspect it's a little bit of everything. You got to figure out how to be in the community and be law-abiding. Maybe this trip to community corrections will let you do that. They approved you for funding. Probation is recommending it. The lawyers think that it's the right place for you. Bottom line, I think it's the right place for you right now today. Here's what we're going to do. In the 2 cases that have felony convictions, 22 CR 1456, which is post-conviction. In that case, probation was already revoked. On count 2, I'll sentence you to a 3-year term in community corrections. On the misdemeanor, I'll sentence you to community corrections on that as well. That's count 3. In 23 CR 1874, on count 5, I'll sentence you to a 3-year term in community corrections. That sentence is aggravated because you were on probation for a felony in 22 CR 1456. The misdemeanor in 23 CR 1874 is count 2. That'll also be a community corrections sentence. 3 years on each case, running concurrently. In the other 5 cases, I'm going to ask your lawyer to please tell me what she calculated as pre-sentence confinement credit. And the sentence is going to be that period of county jail with credit for that amount of pre-sentence confinement credit. So those 5 cases are going to close. You're going to be left with 2 primary cases going forward. Do you understand what I'm doing?
Understand, Your Honor.
Okay. You think that's fair?
Yes, Your Honor.
Okay. So Ms. Briggs, you tell me where you want to start and give me the number, and then I'll impose the sentences.
Sure, Judge. And just one correction.
Yeah.
I'm not disputing that the court can get to the 3-year range on the 3-year number on the 23 CR 1874, but I think he's enhanced, not aggravated on that.
I'm sorry.
Because the
verbiage.
Yeah. So just to make that correction, and then I'll start with L22M 1042.
Yep.
That is a total of 208 days.
208.
208. 23 CR 360 is 201.
Okay.
23 CR 1620 is actually 149, but he had pled to an M2 in that case, so it should be 120 with 120.
Yep.
L23M 962.
Is it 23 or 22?
L23M 962.
I wrote it down. Okay, I'm sorry, go ahead.
132.
Okay. 22 CR 331.
Yes, that has 223.
223.
223. And then if the court would be authorizing credit against the community correction sentences in the 22 CR 1456, that number is 227.
227.
227. And as we previously discussed in the 23 CR 1874 would be 131.
131. Okay. Cal, did you get all those numbers so I can talk faster? All right. In 22 CR 331, I'll sentence the defendant to 223 days in the county jail with pre-sentence confinement credit of 223 days. In L22M 1042, I'll sentence the defendant to 208 days in the county jail with pre-sentence confinement credit of 208 days. In 23 CR 360, I'll sentence the defendant to 201 days in the county jail with pre-sentence confinement credit of 201 days. In L23M 962, I'll sentence the defendant to 132 days. No, that's got to be 120. 120 days in the county jail with pre-sentence confinement credit of 120 days. And in 23 CR 1620, I'll sentence him to 120 days in the county jail with pre-sentence confinement credit of 120 days. All 5 of those cases will close. Court will find the defendant is indigent, waive all waivable fees and court costs, except for victims assistance and victims compensation fund surcharges. With respect to the sentences to community corrections in 22 CR 1456, the defendant will receive 227 days of pre-sentence confinement credit. And in 23 CR 1874, the defendant will receive 131 days of pre-sentence confinement credit. In the 2 remaining cases, I will also make a finding of indigency and waive all waivable fees and court costs with the exception of victims assistance and victims compensation fund surcharges. Mr. Ghana, I'm going to have you wait in custody for transition to IRT and or community corrections. I hope you got a grip on things. I hope that things go better in the future. With respect to the the criminal protection order, Ms. Briggs, did you get
to weigh in on that? Not yet. That's what I was just, I would ask there's actually sort of 2 components. I would ask that the court follow Ms. Cordova's wishes and only keep condition 1 and any other like non-contact related terms that are applicable. It is her son. She loves her son very much. They are going to he's going to be in a structured setting moving forward, given the sentences that the court just imposed. It's easier to just sort of do it now, given that they will have that oversight in place through community corrections. I am also asking, and Ms. Mayfield, this is what she was indicating that she is not objecting to, would be to have the court authorize a medical furlough for Mr. Gauna so that he needs glasses, and the jail has not been able to update his prescription because the prescriptions are only valid for a year. We had raised this issue with the court before, and I was trying to do it on a temp PR bond basis, but unfortunately, our computer malware issue had then occurred 2 or 3 days after the last time Mr. Gauna was in court, so we were not able to get it scheduled in a way where I could bring that to the court's attention when we were originally trying to do it. The jail and his JVBS case manager have set up an optometrist appointment in hopes that the court would grant such a furlough for him. That is scheduled for next Thursday, March 14th at 3 p.m. at America's Best, which is located at 205 Ken Pratt Boulevard in Longmont. They are estimating he would need approximately 45 minutes to travel from, assuming that he is still in the jail at that time, from the jail to the appointment, an hour and a half for the appointment, and then 45 minutes to return to the jail. His mother would be transporting him. The court had previously indicated that at a minimum, it was inclined to authorize a further modification of the protection order to allow that transport to occur. He has been in the jail since his most recent arrest without glasses. It's really difficult for him to see. I've been having to go through and literally reading him like discovery information and documents because he can't read them.
You can't wait until he transitions to work release?
Dead. Could he technically? Yes. Is it difficult for him? And he has been now waiting for this. And we were going to make, as I had previously indicated, the request to the court before on a temp PR bond basis. But due to the computer issues, had not been able to do that.
Ms. Mayfield, they're asking for a furlough on May 14th. Tell me what time he's going to need to leave.
It's
leave at 2, back by 5?
Yes. And it sounds like Mr. Gano was just informing me that it sounds like his case manager is planning to meet them at the optometrist appointment as well, but his mother would be the one transporting them there.
Not objecting.
Okay. Couple things. I'm going to grant the victim's request to modify the criminal protection order to remove the no contact provisions. I understand Ms. Mayfield's concerns, but I also will give weight and credit to the victim's statements where she said that's what she wants. She feels safe. If that happens, she recognizes that he's going to be back in with the family. And I think everybody is of the belief that Mr. Ghanen is a better place now than he was when he committed his most recent offense. So, Mr. Ghanen, you're going to be allowed to have contact. What you need to understand is that there is still a provision under the criminal protection order that prevents you from harassing, molesting, intimidating, retaliating against, or tampering with any witness or victim involved in the 2 cases. And that stays in place. With respect to the request for a furlough, I'll authorize a furlough so the defendant can obtain glasses from 2 to 5 p.m. on March 14th at 3 p.m. Defendant to be transported by his mother. You're available to do it? Okay. He can be released to his mother only. Transportation directly to the optometrist in Longmont. Transportation directly back to the county jail. No detour, no delay, no going to Chick-fil-A for lunch. This is a straight business trip up and back.
Got it, Your Honor.
Okay. Anything else?
No, Judge, thank you.
Anything else, Ms. Mayfield?
Yeah.
All right. Then, Mr. Garner, sheriffs are going to take you back to the jail. You wait for community corrections bed and IRT.
Appreciate it. Would it be all right if I hug my mother really fast?
Nope. You have the right and the opportunity to make a statement. Is there anything you wanted to say?
No, thank you.
All right, it'll be the judgment and sentence of the court. The argument from the prosecution that
Yeah, I should unmute before I talk. Before we get to the next one, if anybody's feeling, that he was too soft and he bent over backwards, he did. However, he sentenced this guy to community corrections, which he completely failed before. So he knows that he's going to get his way in the end. The judge is going to get his way. The judge said clearly, if I could sentence you to more, I would. But the probation office and your lawyers and everybody agrees that community correction is where you belong right now. He knows he's going to bomb. He knows he's going to be back, and he knows he's going to the Department of Corrections. It's just a matter of time now. Yeah. So anybody who thinks this judge is soft and, a pushover, hold on. I got another case for you right here.
stabbing of the victim in 23 CR 568 was racially motivated comes from the pre-sentence investigation report, which is basically quoting the And then both the PSI and the affidavit say, and they continue to yell at Mr. Cotton from afar, and that they refers to Mr. Klingel and Mr. Heisch. So the assertion that this is racially motivated is in fact supported by the facts contained in the pre-sentence investigation report and summarized in the affidavit for an arrest warrant. Usually when there is a plea agreement that involves a range of years to the Department of Corrections, I would give serious consideration to sentencing the defendant somewhere within that range, not at the bottom, not at the top. But what occurs to me as I read the pre-sentence investigation report and review the facts of the underlying case is that Mr. Klingel got a substantial benefit of the plea agreement that he negotiated. And so, Mr. Klingel, I know you're not going to like the sentence I'm going to give you, but what you need to understand is that Mr. Dawson did a heck of a job for you because he captured exposure at a number that I'm going to sentence you to. And I'm going to tell you why I'm going to give you 18 years. Your criminal history is, in a word, horrendous. It is lengthy. It is escalating. Your conduct in threatening the witness in 23 CR 321 is reprehensible. It is aggravating. In and of itself, could justify an 18-year Department of Corrections sentence. Stabbing Mr. Cotton in 23 CR 568, where you caused serious bodily injury, a rib fracture, and a pneumothorax. That crime, too, in and of itself, would justify an 18-year term in the Department of Corrections. The PSI writer says that you pose a considerable risk to the community safety as you've engaged in violent, threatening, and abusive behaviors towards members of the community. That's an understatement. I did note that you indicated you were willing to accept treatment for both your substance abuse and your mental health issues, and I hope that at some level you're able to do that. But you're going to have to do that in a context where you are away from the community, because I see my obligation at this time to keep you out of the community for as long as I legally can, and that's 18 years. I would note that the sentences are aggravated because the defendant was on parole as of the date of offense on all of these cases. He was also on probation, and it is significant to me that the victim wants the maximum. The victim, Mr. Cotton, wants a maximum sentence. In the judgment and sentence of the court, in 23 CR 568, I'll sentence the defendant to an 18-year term in the Colorado Department of Corrections. There's a 5-year period of mandatory parole. The defendant is entitled to 338 days of pre-sentence confinement credit. In case 23 CR 321, on count 2, the possession of a weapon by a previous offender, which, oh, by the way, involved the defendant being in possession of a loaded and stolen handgun. I'll sentence you on count 2 to 6 years in the Department of Corrections. There's a 2-year period of parole. On count 6, which is the intimidating victim or witness, I'll sentence you to a 12-year term in the Colorado Department of Corrections. There's a 3-year term of mandatory parole. In 23 CR 328, I'll sentence you to a 3-year term in the Department of Corrections. There's a 1-year period of parole. All 4 of those sentences will run concurrently. In 22 CR 1480, I'll sentence you to 34 days in the county jail. We'll note pre-sentence confinement credit of 34 days. That case will close. What about restitution in any of the 3 remaining cases, Ms. Cottle?
Your Honor, you are not seeking restitution in 23 CR 328. I'm still working to finalize restitution in the other 2 cases.
Okay, then I will, in 23 CR 321 and 23 CR 568, I will order restitution, the amount to be determined within 91 days of today's date. Mr. Klingel, you are remanded to the custody of the sheriff for delivery to the Department of Corrections to begin serving that sentence.
So that kid in the
Deputies,
background,
thank
that kid in the background that was, with his hat on and everything, he was actually in front of the judge before, earlier in the docket. And he's like, hey, can I just hang around because I'm friends with this guy and I want to see, I want to see what happens in his case. But yeah, so this judge is not a pushover. He's not. He's definitely not a pushover. Um, that guy had 18 years sounds like a lot, but man, he should have gotten a lot more. Okay, we got one more, and it's a love story. But you won't know it's a love story until you get into it. But it's a love story.
Molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing, you shall refrain from contacting or directly or indirectly communicating with the victim and or witnesses. You shall stay away. You shall vacate the home of the victim. And because this is governed by Brady, you shall not possess, purchase, or control a firearm or other weapon. You shall not possess or purchase any ammunition, and you shall relinquish for the duration of the order any firearm or ammunition in your immediate possession or control, and shall do so within 24 hours. If you are in custody and cannot relinquish firearms and ammunition, the court orders you to do so within 24 hours of your release from custody. You shall file proof of relinquishment with the court and within 3 business days of the relinquishment as required by statute. I did order that you shall vacate the home of the victim here. Are you going to need to return to that address in order to retrieve some belongings?
Well, Your Honor, yes, my vehicle, but there's something that, I moved here to be with Jean a year ago from Seattle. So I'm new to this area. I've been living with him for a year, paying rent at the house, and yes, he is the owner of the home, but I've
He
been the
is the
one that
owner.
has been supporting the
Remember.
household since I got here. And so the only thing I ask is if there's anything. I understand I can't leave the state, but I don't have any family here at all. I don't have a home. I have a job, but I don't have a home. I don't have anything here. If I'm released today, I'll be homeless if I'm not allowed to return to the home that I've been living and paying for this last year, sir.
I do understand that, and I understand that position. Ms. Dowdell, do you have any objection to a one-time civil standby, at least at this time?
No objection, thank you.
Okay. So I will order a one-time civil standby. What that means is that you'll be able to go and get your belongings in your vehicle, any uncontested items from the home. I'm not going to at this time wade into who is going to have control of the home, as that's not what is in front of the court today. I understand that position, but I'm not going to take any action on that.
So does
I
that
will order that one-time civil standby as I just stated. Do you have any other questions about that protection order at this time?
No, I'm just going to be homeless because that's been my home. I've been living there, Your Honor. I have nowhere to go. And if I'm not allowed to leave the state, I'm walking out into a snowstorm right now. I live in Kremling and I'm in Grand Junction right now. I have nothing.
If you were allowed to leave the state, where would you return to?
I would go back to South America where all my family is. I don't have any family. I was adopted.
Okay. That is going to remain the order of the court right now. I'm sorry that is going to be the order of the court, but it is. We will need a next court date for you.
Do I have any available resources for myself tonight? I don't have any place to live. I have nothing. Jean has his mother's house, his father's house. I have nothing. And I've been paying for that house for an entire year, Your Honor. I'm the one that's been making the payments for the bills. So I'm in a really bad position, and I need help.
Okay. Ms. Dowdell, do you have a position regarding that today?
So, Judge, we would leave it open to the court. Obviously, we would be
Okay.
concerned with anybody leaving the country.
Yeah, I agree. I do have concerns about leaving the country.
I don't have any options, Your Honor. I have a mother that lives in South America that I haven't seen in 40 years. She would be the only one that I could reach out. But as far as anyone in the States, I don't have anyone to, especially here in the state. I don't know anyone.
Okay, I understand. Do you intend to apply for the public defender like we had talked about earlier?
Say that one more time.
Do you intend to apply for the services of the public defender?
Yes, Your Honor, I do.
Okay.
Yeah, once I can gather myself and get my stuff and stuff like that. I have a lot of stuff in the house. Are they going to be able to wait till I move all that stuff out? How does that work?
You'll need to get in contact with I believe the sheriff's office, and they can help you set up the one-time civil standby.
Okay. To take out like furniture and bed, they'd be there that entire time with me as I'm taking all of that out.
Right. So they would be there to assist in the civil standby. That'll be uncontested items, things like that. And they will, I think, give you some guidance on how that works. Okay.
Is there a reason why I'm not allowed to return to the home where I live, and he can go to his mother's home?
That is a standard condition of the protection order in cases like this one. Certainly, I will say that the people are on notice that there will be a request to modify that protection order at the next hearing, but that is going to remain the order of the court right now. I will set your next court date to March 19th at 10:30 a.m. So that you can address it at that time.
March 19th. Okay.
And that will conclude the matter today.
Okay.
I promised you a love story. Don't worry, it's coming.
All right, and who do I have in the courtroom, the video courtroom at the Grant County Jail?
Yeah. How do you pronounce it? It's Fleischer. Mr. Fleischer.
Okay. Thank you, Ms.
And that, my friends, is her partner. They're both in jail at the same time.
Mr. Fleischer, this is 24M61, People of the State of Colorado versus John Fleischer. Mr. Fleischer is appearing from the Grand County Jail in the video courtroom. Mr. Schaefer is here from the Public Defender's Office, and Ms. Dowdell is here on behalf of the people. Good afternoon, Mr. Fleischer. My name is Judge Hessen, and in just a moment we are going to, I am going to set bail because we are here for a bail hearing today. First things first, I'd like to tell you that you have the right to an attorney at all stages of the proceedings, including this one. And because you are in custody, Mr. Schaefer is here to represent you for your bail hearing today. Would you like me to appoint him to assist you in making a bond argument today?
Yes, please.
All right, Mr. Schaefer, you are appointed for the purposes of the bail hearing today. Have you had the opportunity to speak with Mr. Fleischer?
I have, Your Honor, and can waive a formal reading and advisement.
Thank you, Mr. Schaefer. I will hear from the people first regarding bond and the protection order.
Your Honor, the people see no criminal history of note. We have no objection to a $750 PR bond. We would ask for a no contact mandatory protection order, box 1, as well as Brady provisions. Thank you.
Thank you, Mr. Schaefer.
Your Honor, no objection to the protection order or the request for a PR bond by Ms. Dowdell. The only thing I would note is that in speaking with Mr. Fleischer, he is the owner of the home that they had been cohabitating in, and he does not wish for Miss, I'm going to pronounce it poorly, but Aggravated, he doesn't wish for her to be able to stay with him there. I suppose that information's as much for Ms. Dowdell as anyone. And so he would ask to be able to remain in his home with that no contact protection order not in place, but otherwise no objection.
Ms. Dowdell, are you requesting that the court order that he vacate the home?
Judge, I am, and I know it's a little confusing. I don't think that the court, the people, or anybody is in a position to make a determination about who owns the home. We don't have any information about that besides somebody who's in custody's word. So I think that they both get vacate the home provisions, and yeah, I don't know what else to do there. I don't think we're in a position to make a determination about who has ownership.
Thank you, Ms. Dowdell.
Your Honor, if I could just
Sure.
briefly respond. It's not one person's word. Both co-defendants this afternoon have attested that Mr. Fleischer's the owner. All of Ms.
She did say
Aragonid's
it.
representations were that she contributed to rent payments. So I believe that the same representations by both are appropriate to make a determination today. But that's just my stance.
Thank you, Mr. Schaefer. All right, I will start with the bond. I am going to follow the recommendation of the people and set bond in the amount of $750. Personal recognizance. In addition to the standard conditions of bond, Mr. Fleischer, you shall not leave the state without the permission of the court. You shall immediately notify the court of any change of mailing address or residence, and you are to comply with all conditions of the mandatory protection order that I'm going to enter in just a moment. Do you understand those bond conditions?
Yes, I did.
Okay. As for the protection order, I am going to find that this is governed by the Brady Handgun Violence Prevention Act. This protection order will protect Soraya Aragundi, date of birth 6/1/1979. That protection order is going to state that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing. You shall refrain from contacting or directly or indirectly communicating with the victim and or witnesses. And as for the provision regarding vacating the home, I do agree with Ms. Dowdell that at this time it is not appropriate for the court to wade into the question of who owns the home. I understand Mr. Schaefer's position regarding there being multiple individuals who mentioned that, but it is not the court's place, I think, at this time to make that determination. So I am going to order that Mr. Fleischer shall vacate the home of the victim. And because this is governed by Brady, I will also order that he shall not possess, purchase, or control a firearm or other weapon, and shall not possess or purchase any ammunition. Additionally, you shall relinquish for the duration of this order any firearm or ammunition in your immediate possession or control, and you shall do so within 24 hours. If you are in custody and cannot relinquish firearms and ammunition, the court orders you to do so within 24 hours of your release from custody. You shall file proof of relinquishment with the court within 3 business days of the relinquishment as required by statute. Do you understand that protection order, Mr. Fleischer?
Yes, Your Honor.
Okay. All right, I will need to set a new court date. Mr. Fleischer, do you intend to apply for the services of the public defender once you've bonded out?
I believe I will, Your Honor.
Okay. In that case, I am going to set this on March 19th at 10:30 a.m. You will be appearing in Grand County in front of Judge Catanzaright. Do you have any questions about that?
No, I do not.
Okay. Is there anything further in this case, Ms. Dowdell?
Nothing, Your Honor. Thank you and have a nice weekend.
Thank you, you too, Mr. Schaefer.
Yes, Your Honor. I'd ask the court to permit a one-time civil standby for Mr. Fleischer in light of the home vacation order.
Thank you for bringing that up, Mr. Schaefer. I will also authorize a one-time civil standby in this case so that Mr. Fleischer can return to the home and get his belongings. Anything further, Mr. Schaefer?
No, that's it. Thank you.
Thank you. All right, Mr. Fleischer, Judge Catanzaright will see you on March 19th at 10:30 a.m. Thank you very much.
So we kicked both of them out of the house. Neither of them can live there. Now, like she was saying, he has places to go. He has his parents, he has friends, other family. She has nowhere to go. And the first thing his lawyer said, well, not the first thing, but one of the first things his lawyer said was, yeah, he doesn't want her in the house anymore. Oh my gosh, that's so rude. So how is these civil standbys going to work? All right. I know that she said she wants to get her furniture, blah, 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 and that's not how it's going to go. The judge knew it. The judge didn't say to her that she was going to be able to, but he didn't really tell her she was not going to be able to. He just let that up. He just left it up for her to find out the hard way. But he's not going to be in the house when she comes in to get her stuff. She's not going to be in the house when he comes to get his stuff. So that's going to be a nightmare. I would take all of his stuff if I went there first, because he's not allowed to be there. I would take everything. I don't know how that's going to work, but and she's like, "Oh, I need to get my furniture." Where are you going to take your furniture? You don't have anywhere to go. You have nowhere to go. I don't know what's going to happen with those two. I have a feeling their love will prevail, guys. So at the very next hearing on the 19th, they're both going to drop charges against each other and beg for their love to live. And Cloud, and they're going to beg for conjugal visits. Yes, they are. I think you have to be married for that, don't you? All right. Anyway, that's what I got for today. I'm going to go check out oh my gosh, you guys were just talking about it, and then DeSantos. I'm going to go check out DeSantos. I love her. Love her, love her. But now I have to go to sleep. I need a little bit of sleep before work. It's the weekend, and I get my courts live. So I don't know. I don't know if I have it. I have a little bit saved up. We'll see if I can find something from that tonight. But I don't know. I might not see you guys till Monday. But, when I'm watching this, I think about you guys all the time. Like, oh, Jim's going to really like this. Oh, Kelly's going to like this. Cloud's going to like this. Raven, first you said that I sniped Meg's stream. And then today you called me a clickbaiter. Which I'm neither. Oh my. And hello again from Australia. We had Australia. Oh, I should say. You know what? I'm going to say. So, shout out to Texas. That's the state where I get most of my viewers. Texas Vernon probably lives there. We love him. You got to read his comments on my channel. Texas Vernon is so funny. And then next is California. And then next is Florida. Next is Michigan. And then Ohio. Those are my top 5 states. And I feel bad because, I moved away from them. I guess I could get Texas. No one else really does a lot of Texas. I can't get California. They just don't show their courts. I can do some more Florida though. Michigan, I don't know if I want to do Michigan because everybody does Michigan. And people are starting to do Ohio more, so I don't know. But shout out. Thank you so much for watching, guys. Hey, Kelly, you're in Texas. Tina, you're in Florida. Okay. I can get some more Florida. They don't have an awful lot, but there's a little spot that I can get, a little courtroom that I can get. Yes, Raven, I called you out. You keep accusing me of things. And, I might have did it. Who knows? But no way. You're in Finland? That is crazy. Courtroom 134, 36th District Court will be live with first appearances. All right. Tarrant County, I'll look for that. I will look for that, guys. I will. You know what? I'm going to look for Finland cases now, too. Look for Australia. I do have the Australian court. I'm a subscriber of the Australian court. But it's like their Supreme Court, so it's not like the cold cases that we see here. It's not. It's more of just argument, and then 3 weeks later they give their decision. So it's hard. Oh, sorry, Raven. Go back to bed. I'm gonna go to bed too. All right, guys. You guys have a great weekend, and I will talk to you soon.